Any company with 2 or more shareholders really need to have a shareholding agreement in place. This is because the shareholding agreement itself outlines the terms and obligations of each shareholder to the other shareholders in the business, and it outlines certainty as to how the business is going to run moving forward and what each shareholder's rights are in respect of that business. The first is that the shareholding agreement will outline how directors are appointed to the company and the roles and responsibilities that they have within the company. A shareholding agreement will also outline key decisions that have to be made on the operation of the company and who can make those decisions, whether it's directors or shareholders. A good shareholding agreement will have a clear process as to how shares held by a shareholder can be transferred or sold. For example, whether the shares have to be first offered to all the existing shareholders in the first instance before selling to outside parties. Often a shareholding agreement will have restraint clauses contained therein which will allow for leaving shareholders to be restrained from entering competitive businesses or companies in similar industries. There's also an important aspect about a good shareholding agreement is triggering events of default, and that clearly needs to be defined within the shareholding agreement so that if shareholders are in breach of the shareholding agreement, then it could potentially trigger the sale of that shareholder's shares in the company. It's also important that a shareholding agreement has got confidential information and privacy clauses so that exiting shareholders must comply with their confidentiality obligations upon leaving. The original shareholding agreement, if it's set up correctly, should have various annexure documents to it, and one of those documents should be a simple deed of accession, which can be a 1-page outlined letter that outlines that a new shareholder who comes on board signs that deed of accession and essentially agrees to the existing terms and conditions of the existing shareholding agreement. So if a shareholding agreement is not in place between the parties, then there can be a lot of uncertainty as to decisions that have to be made within the company. It could lead to disputes without any mechanism for resolution of those disputes before heading into court. There isn't any certainty as to how to sell shares within the company and who can buy those shares. There's also issues around who can appoint certain directors to the company and what the power of the shareholding or the nominated shares that you hold will have within the company. The other aspect is that there could be issues around dividends and how dividends are issued through the company, and if you don't have a shareholding agreement in place, this is a policy that could be a little bit messy and undefined. A shareholding agreement can simplify all that, put a set process in place and allow for certainty between shareholders as to how and when dividends get paid. Setting up a shareholding agreement and the time taken for that to happen will depend upon how many shareholders are coming into the agreement and what each shareholder is seeking to achieve or wants within that shareholding agreement. Ordinarily, we'd have an initial meeting with all the shareholders where we'd take that down. The agreement gets drafted and circulated out to the shareholders to then take their own advice on, and then come back together and finalise the document. This, with a handful of shareholders, could ordinarily take 1 to 2 weeks.